My name is Dale Dutt, and I'm from Boise, Idaho, and I'm here to discuss judicial corruption across the board. I'm representing my son. His name is David Sean Dutt. He has got a 30-year sentence for having sexual intercourse with a girl who was a virgin at trial. Her hymen was intact. Her sexual exam showed normal for her age. The testimony presented in court was that a child between the ages of 11 and 15 have so much estrogen in their system, for girls only, that if a man knows what he's doing, he can have hardcore sex with that child and leave no signs of sexual abuse. My son's lawyer refused and told us we could never afford to have a doctor come and argue against that testimony, and so nothing was ever presented and there wasn't a defense in regard to that issue. This is the way the court system is run. Since my son's conviction in 2001, he got a 30-year sentence. He's done 11. 3 of that 11 years has been done out of state, where the state ships him off to another state so that they can receive federal funding for overcrowded prison system. And all of this corruption happens because all of these agencies are private companies, including Ada County prosecutors. The prosecutors themselves are private agents of that corporation. The county is corporate, the state is corporate, they have no sovereignty. If they've accepted federal funding according to the Clearfield Doctrine, they have no sovereignty, and therefore every law they make is what they themselves call a statutory scheme. And that statutory scheme sets up the whole issue. In my son's case, we've uncovered the fact that there's an agency called Victims Witness Compensation Fund. The Victims Witness Compensation Fund is fed by federal funds to the tune of $170 billion a year. The Greg Bauer, the lead prosecutor in Ada County, brought those funds into this state and has been lead prosecutor ever since. It's bought him enough political clout and pension. This is handled by the pension fund company in this state called the Industrial Commission. The Industrial Commission is literally an insurance company for the state, for pensions, and for the judges, the prosecutors. And I believe that the attorneys all contract. They're all officers of the court. It's just a mess. As we've started our investigation, we focused, and I made a mistake of focusing for 10 years on the lie that was printed at court. How could he have sexual intercourse with a girl who the record shows is a virgin? How can that occur? And a lawyer told me, in order for a lie to stay in court, you have to know the truth and know how to stay away from it. So I went back to the files and I started going through everything, and I believe now I've found the lie. The lie is called brain freeze. The lie is called fraud upon the court. Fraud upon the court has no statute of limitations, and it is the lie that was presented. In my son's case, they did a 404B motion. They had a grand jury. We're not even sure that they had a grand jury. It's signed by a member of the grand jury, not by the foreman. Through the whole grand jury transcript, the prosecutor is testifying as though she has firsthand knowledge. They had an indictment on my son and his wife, who was a co-defendant. She was acquitted. He was convicted by the same testimony of the same victim. In regards to the evidence, all the evidence proved he could not have done the crime, and yet he was convicted. The courts are not about truth. They're not about justice. The courts are about money. I believe my son's case was probably utilized through the Victims Witness Compensation Fund, and they've probably insured that case the minute that it was filed for a lot of money. And it wasn't about losing the case. It was about winning the case and taking the funds. Period. The end. There was an indictment, and after the indictment they did a 404B motion. The 404B motion has three things so that the 404B is in play. Have to have a victim, have to have testimony to the event, and have to have no question of credibility. They changed my son's records, and in the repository in the state, it shows that he was arrested 3 times in 1999 for 3 separate sex crimes. He was never arrested in 1999, and I have here in this paperwork his concealed weapons permit and a taxi cab driver's license that he got in 2000 and 2001, both requiring a background check. Now, the way I know that the record was changed is because I also have his wife's record. And they didn't take off the arrest for the year 2000 on hers when he was arrested. But on his record, that arrest is gone. These 3 charges are what they used in the 404B to bring forward uncharged previous allegations. Now, this would stand in court, the 404B would be legal if there was no question of credibility. But the child's aunt came forward and said, I believe she's lying. When they said that, the prosecutor went ballistic and she filed a motion with the court October 12, 2001 to dismiss and exclude a witness for seeing the grand jury transcript. That's the purpose of the motion to exclude. There's only one problem with that, and that is that I have the motion to exclude a witness is here. That was the indictment. After the motion to exclude, notice the dates at the top left-hand corner. This is October 12, 2001. Here is a motion to release grand jury transcripts. It's dated October 17th. How could this witness that they're trying to exclude seen the grand jury transcripts before the court ever released them? So this is called fraud upon the court. Then, here's another record I have here of my son's attorney receiving the grand jury transcript on the 17th. So he's gotten the transcript on the 17th, and then they have a hearing on the 23rd of October where the attorney, my son's attorney, they have this meeting, and it's interesting they titled this meeting Criminal Minutes. That's the title of this meeting. Closed in the judge's chambers, it's called Criminal Minutes. The defense attorney admits to showing the aunt the grand jury transcript, which she couldn't have seen because they hadn't been released by the time the motion was made to withhold her testimony. The judge saw that that wouldn't stand, so he didn't allow her to be withheld from trial. Then the prosecutor puts in a motion called a motion in limine. Once a motion in limine is put into play, you cannot argue about the motion. In the motion in limine, it states, we cannot have a mini trial within a trial to test the validity of the victim's disclosure. How do you defend yourself if you're not allowed to present that the disclosure is false? You're not allowed. If you're not allowed, you have no defense. If you have no defense, you've not been duly convicted. If you've not been duly convicted, then the fraud upon the court has to stand, and every decision of that court is null and void. We need to understand our rights. We need to educate people. We need people to understand that this system is corrupt to the core. Judges, lawyers, they're paid, they're officers of the court. They're all deemed to know the law, and they're responsible and liable.